answer those questions whenever it is possible, and if it is not possible during the live sessions, in that scenario, all the questions will be definitely be answered in the dedicated Q&A section. Please avoid interruptions while the speaker is presenting. And with that, it gives me immense pleasure to introduce you all to the speaker, the guest of the day, who is Vinay Prabhakar Navare, sir. Sorry about the name, sir. So we welcome you all, sir. He is a senior advocate of the Supreme Court of India, widely recognized for his expertise in constitutional law, property law, and international law. He brings with him over 3 decades of experience, having practiced extensively in Bombay High Court and Supreme Court of India. He was designated as senior advocate in 2019. He has appeared for key municipal corporations and government panels at the highest level of judiciary. Academically, he has completed his LLB and LLM from University of Bombay and has done Masters in International Law from University of Netherlands. And beyond this courtroom experience, Mr. Navare has shared his knowledge as a teacher in business law and contributed internationally as well through the project with the International Labour Organization on Labour Disputes Arbitration in Cambodia. Please join me in welcoming Mr. Vinay Prabhakar Navare, sir. Thank you so much, sir, for being here with us. We are hoping and we are looking forward to this insightful and detailed session. And now we can, I believe, move to the session. Over to you, sir.
Yes. Thank you very much, Richa, and also Mr. Mithilesh, for your initiative for law education and giving some kind of exposure and understanding to the young budding lawyers or the law graduates aspiring to be the lawyers. I chose this subject of drafting of the writ petitions today because of my experience as a lawyer practicing in the Supreme Court. When I used to get the copies of the writ petitions filed in the High Court, I used to see that they were very casually drafted. And I thought that something which is inherently missing in these petitions needs to be underlined, needs to be listed, so that the young lawyers get some idea of what way to go about while drafting the writ petitions. With respect to drafting, I will come in later part of my session. Initial part of my subject will be covered or will be touching the some theoretical aspect of it, and that I think is extremely relevant, extremely crucial for being able to draft a proper writ petition under Article 226. I think something elementary which I am sure most of you, all of you know, the difference between Article 226 and 32. I'm not going to dwell upon that. Article 32 confers the original jurisdiction on the Supreme Court of India to entertain the writ petitions and issuance of various writs for enforcement of fundamental rights. But 226, it is said, that confers similar jurisdiction on the High Court, but of a wider nature. The power of the High Court under Article 226 is much wider, and it's not only for enforcement of fundamental rights, it is for enforcement of our ordinary rights also. But therefore, I said the difference between Article 32 to 226 is not what really is important from my point of view for my subject. Before we understand what is Article 226, we may just have a look at what is Article 227. Please have a look at, I have just requested Richa to have a PowerPoint of some of the keys of my subject. Please have a look at Article 227(1). Every High Court shall have power of superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. So the nature of power of the High Court under Article 227 is of a supervisory jurisdiction. And if you see the later part of Article 227, the impression that you may carry is it is more of administrative nature, but it is not. It confers a judicial power also of supervising the exercise of jurisdiction by the courts and the tribunals functioning within the jurisdiction of the High Court. So, but what is the difference in Article 227 and Article 226? Article 226 also confers similar power on the High Court, but Article 226 confers power on the High Court to issue writs of various natures that we will come to later. When we make an application, I don't know what is the practice in other high courts, but I know in Bombay High Court, when a petition under Article 227 is filed, it is also called writ petition. So writ petition either under Article 227 or under Article 226. But when we make an application under Article or petition under Article 227, we don't pray for or request for issuance of any writs, because that's a supervisory jurisdiction, and whether the courts or tribunals are functioning within some bounds within which they are supposed to function or not, this is the subject of scrutiny under Article 226. Having said that, please have a look at Article 226, and I have marked some part of Article 226 in bold version. That's what is going to be the focus in my discussion about Article 226 initially. Just let us read that, it may take half a minute. Notwithstanding anything in Article 32, every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction. Now, first bold portion is to issue to any person or authority. So the writ can be issued against any person or authority. Any person I will come to later, including in appropriate cases, any government within those territories. Now this is something important: directions, orders or writs. So High Court under Article 226 can issue various writs. It can issue orders, directions. There is no limit of a particular form of order which the High Court can issue under Article 226. Now this is next term which is marked in bold is including writs. So including writs shows that apart from writs, there are various other kinds of directions in orders which can be issued. For example, the High Court can issue a declaration under Article 226. For example, somebody's services are terminated. Before you make a prayer for setting aside that termination, you seek a declaration that hold and declare that this honorable court be pleased to hold and declare that the termination order dated so and so of the petitioner from so and so is illegal and bad in law. So not specifically referred to, but it is inclusive of power under Article 222. Therefore, the use of the word including. Writs in the nature of those 5 writs are referred to, and I will come to that later, or any of them. Now this is again important for the enforcement of any of the rights conferred by Part 3. Now why I have marked this portion enforcement of any of the rights? This is to distinguish it from Article 32. As I said, Article 32 confers power on the Supreme Court for enforcement of fundamental rights. Article 226 confers similar power for enforcement of any right. It can be statutory right, it can be right arising out of customary law, and therefore it is wider in nature. Conferred by Part 3. Part 3 deals with the fundamental rights conferred upon the individuals or the citizens, and for any other purpose. I have again marked this in bold portion. And for any other purpose, it gives still a wider implications to the nature of power of the High Court under Article 226. So it can be for enforcement of any of the rights or for any other purpose. Now, what is that any other purpose? It is left to the discretion of the High Court. Please note the bold portion of the Article 226(1) again in your mind, so that you understand the implications of what is the nature of power of the High Court under Article 226. Now, having said this, I must come to the next part of the theme that I have in my mind. We have referred to these 5 writs: habeas corpus, mandamus, prohibition, quo warranto, and certiorari. But I must tell you, there is always a confusion in the minds of the lawyers with even good experience of 5-10 years. What is the difference between mandamus and certiorari? We must understand that clearly. See, you must, therefore, this PowerPoint of these 2 points, I am highlighting this. Mandamus is to be issued against the administrative authority. Please note this. When you seek a writ of mandamus, it is always directed against the administrative authority and not the tribunal or quasi-judicial authority. And certiorari, writ of certiorari is to be directed or issued against the tribunal or quasi-judicial authority. This is something fundamental. This is something elementary, and we should not miss it. I have seen many a times the prayers made in the writ petition that writ of mandamus be issued against the so-and-so tribunal. You don't issue the mandamus against the tribunal unless in a particular case the tribunal is declining to exercise the jurisdiction which is vested in it. That's a different thing. But ordinarily, certiorari against the quasi-judicial authority and the mandamus against the administrative authority. Now there is one more writ which is something that you must keep in mind, writ of prohibition. Writ of prohibition also gives some kind of, leads to some kind of confusion. See, there is a difference in the injunction and prohibition. Prohibition in the writs, law of writs, when you talk of law of writs and writ of prohibition, it is directed against the quasi-judicial authority. When a tribunal or quasi-judicial authority is likely to exercise a jurisdiction not vested in it, then you issue a writ of prohibition against the tribunal or the quasi-judicial authority. When you seek an order of some prohibitory order against the administrative authority, it is essentially in the nature of injunction, and that I think the ordinary lawyer understands what is injunction. But prohibition essentially is directed against the quasi-judicial authority. With respect to other writs, habeas corpus, everybody knows habeas corpus has one distinct feature, and just keep that in mind. I had highlighted in Article 226 when you read that the word persons, it can be issued against persons or authority, including the government. See, writ of habeas corpus can be issued by the court even against an individual, because the highest and most supreme right, protection conferred by the Constitution of India is of personal liberty. If somebody's personal liberty is in danger, the court can go to the extent of issuing a direction writ even against an individual, and habeas corpus is essentially produce him. If somebody is kept in captivity or kidnapped and the court is informed about that, the court in appropriate case can issue a direction either against the state authority or against even an individual, against a person, to produce him before the court, and then the court will examine whether the restrictions, restraint on that individual are legal and valid. So this is about the various writs which can be issued by the High Court. Quo warranto, I think we will not spend much time on that. Quo warranto is by what authority do you hold a particular post? If somebody is occupying a public post without the in violation of any law, in that case the court can call upon that individual who is occupying that public office to explain by what authority he holds this post. In that sense, the court, the quo warranto. But I have already talked about it. Apart from these writs, there can be other reliefs which can be granted in the nature of declaration, in the nature of injunction, etc., etc. And therefore, the power of the High Court under Article 226 is extremely wide. When you file a writ petition or draft a writ petition, we must also bear in mind one thing: against whom writ petition can be filed or against whom the reliefs can be sought. Please remember one thing, that the writ jurisdiction of the Honorable High Court is a public law remedy and not a private law remedy. What is the difference in public law remedy and private law remedy? When, for example, I have a contract with somebody about which I am supposed to hand over some articles to, and he is supposed to pay me back the price for that. That contract is, if it is violated, for example, I have handed over the articles, but my money is not entirely paid. I have a remedy against him to go to the court and seek a relief against him of for payment of money. But that's a private law remedy. I can file suit in the court and seek a remedy against him. The essentiality of writ jurisdiction is that it is a public law remedy, and therefore you can seek a relief of issuance of any of the writs from the High Court only against, essentially against, the public authority for enforcement of your right, or for violation of any of the rights, or failure to comply with the duty which is cast on some public authority. So you can't file a writ petition against an individual. For example, if, as I said, my monies are to be received after I've delivered the articles from an individual, I can't file a writ petition under Article 226 against him for seeking a direction against him to pay the money to me. This is something elementary. It's a public law remedy. This is something that we must have. Now, as I said, it's a public law remedy. So against whom you can maintain the writ petition, against whom you can file the writ petition. There, the High Courts and even the Supreme Court have evolved some tests how to find out against whom you can maintain the writ petition. And for that, definition of Article 12, definition given in Article 12 of the concept of state is extremely relevant. Please have a look at the definition of state under Article 12. In this part, unless the context otherwise requires, the state includes, I have again marked some portions of this definition of state in bold letters. Includes the government, Parliament of India, the government and the state legislature of each of the state, and all local or other authorities. Now I will come to the portion which is marked in bold letters. In this part, so the definition of state is restricted only to part 3 relating to fundamental rights. This definition applies only for the purposes of enforcement of fundamental rights. One thing. Includes the government. So the constitution makers have been conscious to make the concept of state an inclusive definition, so that not only what is stated therein, but there may be some other authorities also which may fall within the definition of state. And then we come to local. Other things I think you have understood, the government of India or the Parliament of India or the government or legislature of a state, they are obviously state. All local authority. Local authority means the municipal corporation, for example, the market committees, etc., etc. But other authorities is the term which has attracted the attention of the courts. What way to understand, what way to explain what is the meaning of other authorities. And the courts have, over a period of now more than 7 decades, laid down certain tests to find out which authority will fall within the definition of state. I will just point out what those tests laid down by the courts are. One is, if a particular entity is an agency or instrumentality of the state. For example, just see these 4 tests which are extremely crucial. Test of agency or instrumentality of the state. I will give one example. Airport Authority of India. Airport Authority of India is an independent entity. But Airport Authority of India works as an instrumentality of the government of India. All airports are under the control of the Airport Authority of India. And you know what is the importance of airports for the purposes of commerce, for the purpose of international travel, and who will come inside India, who will go out of India. Everything is controlled through the airport in India. And therefore, that Airport Authority of India is an agency or instrumentality of the state. Second test which is evolved by the courts is, any such entity should be under the financial, functional and administrative control of the state. State means the government. I will give the classic example of the such entity. Take for example the universities which function. Universities which are created by the statute, they are created by the statute. All functions of the university are for the purposes of carrying out the government function, and therefore funding of the university is substantially done by the government. Appointments of the vice chancellor, registrar, etc., happens under the statute as regulated by the government. So financial, functional, and administrative control, if that is happening with respect to that entity by the state, then it becomes a state under Article 12. Such control, third test, such control must be pervasive. That is completely so effective, so tight that that entity cannot function independently without that pervasive control of the state. So this is the third test, and the last test is that entity discharging a public function? In that regard, I will give one example. Even a private school, but aided school, it discharges a private function. A writ petition, it is held, is maintainable against aided private school because it is discharging a public function of imparting education. Imparting education is a public function, and therefore even private aided school has been the subject to the control of the high courts under Article 226. Now, having seen this theoretical aspect, which I said that it is the beginning of my subject, the next part, when you come to drafting of the writ petition, please remember two things. One of them I have already explained, that it is a public law remedy. But first one in this slide you will see, these are original proceedings. There is nothing which has happened in some lower court, civil judge, junior division, or judicial magistrate first class, or sessions court, or district court. It is happening by way of proceedings in the high court for the first time. They are original proceedings. If they are original proceedings, just remember this is something extremely important for the purpose of drafting of the writ petition. All relevant facts, all relevant documents, all relevant pleadings should be incorporated in the writ petition. You can't do it casually. I see many a times as if an appeal is drafted, the writ petition under Article 226 is drafted. I feel very sorry about it. I feel very bad about it. These are original proceedings, and therefore what is to be kept in mind is all necessary pleadings, all necessary facts and circumstances, all necessary documents should be part of your writ petition, and that is extremely important while drafting the writ petition. Now, when writ petitions are filed, there are 3 or 4 difficult situations at the threshold, which also has to be kept in mind when you draft the writ petition. See, writ petitions many a times are rejected at initial stage. What are those initial stages, or what are those initial grounds on which writ petitions may be dismissed? Please have a look at these. Precautions for addressing preliminary grounds of rejection. First, alternate and efficacious remedy. If you have a certain right and you say that your right is violated and you go to the High Court under Article 226, if you have a remedy against that violation by knocking the doors of some authority, some tribunal, etc., you can't straight away come directly by way of writ petition under Article 226. I will give an example. If services of a teacher are terminated by the college which is affiliated to the university, there are many statutes in many parts of India. I have seen at least 3-4 states from which such statutes are there. There are many statutes which provide that in case of termination of a service of a teacher or any employee of an affiliated college, the university tribunal has a jurisdiction and appeal is maintainable to the tribunal. So you can't challenge. The college may be aided college, so writ petition theoretically is maintainable. Or for example, government servant, if his services are terminated, writ petition against the government is obviously maintainable, but there is a remedy under the State Administrative Tribunals Act of approaching the administrative tribunal. So unless you exhaust that alternate remedy, you can't straight away directly come to the High Court under Article 226. First thing to be kept. So when somebody approaches you for filing a writ petition, you must examine whether there exists any alternate remedy, alternate forum before that grievance can be agitated. First. Second is disputed questions of fact. If there are disputed questions of fact, see, writ jurisdiction, strictly speaking, doesn't go into the procedure of recording of evidence, cross-examination, etc., etc. So, disputed questions cannot be gone into in the writ jurisdiction. So, when you file a writ petition, you must assess, you must examine whether what is alleged, what is stated in the writ petition is substantially undisputed on the basis of documents which are undisputed. If it is a case of disputed questions of fact, the remedy lies in the civil court. You go and file a civil suit in the civil court. The third aspect, the restrictive element that you must keep in mind while drafting the writ petition, it's a grant of relief under Article 226 is a discretionary remedy. Court is not bound to issue writ in all cases. There are cases where court may decline to issue such, even if the court is satisfied about some violation of some right. Because it is discretionary, there is fundamental rule that whenever there is a discretionary jurisdiction conferred on the court, you must come before the court with clean hands. That is, you must not suppress anything from the court. You must disclose all relevant things, even the material which is against you in your writ petition. If you don't disclose such relevant facts, relevant material, relevant document, there is great likelihood that the High Court may dismiss your petition because you did not come to the court with clean hands. So these are the cautionary rules when you draft a writ petition. Please remember these 4 rules which are extremely material relevant when you are drafting a writ petition. Now let us go to the next aspect of the matter, drafting of the writ petition. See, when you knock the doors of the High Court under Article 226, in your pleadings, when now you are actually now starting the work of drafting the writ petition, the first and foremost thing that you need to do is, what is your locus? What is your locus means how are you concerned with the issue that you are raising in the writ petition? How you are affected by the action or the decision of the government authority against which you are seeking relief. If you don't explain that, if you don't show that you are the aggrieved person, the court may decline to consider your case. So the most important thing when you draft the writ petition, and that's the initial paragraphs of your writ petition, the first thing you explain is who the parties before the court are. Petitioner is so and so, so and so. For example, he's residing is not important. What he does, in what relation he's coming to the court, etc., etc. And then who are the respondents? And then the first paragraph that you have to start with is explain your locus. Who are you? How are you concerned with the cause of action you are raising in the writ petition? This is what is termed as locus. So first thing in drafting the writ petition is explain your locus. Second, when you are arraying some respondents as parties and seeking relief of issuance of writs against any of the authority, you must explain and satisfy the court through your pleadings that the respondents are amenable to the jurisdiction of the High Court. I will give an example. You can file a writ petition against the government of, for example, if somebody is from the state of Gujarat and he wants to file the writ petition against the state government of Gujarat. You can always say that respondent is the state of Gujarat and it is the state within the meaning of Article 12 and it is amenable to the jurisdiction of the High Court. But take a case, for example, there is some cooperative society where some work of the government is given to that cooperative society And in that regard, there are some grievances that you have, and you want to file a writ petition. Whether that respondent, that society, is a state within the meaning of Article 12 or not, whether the writ can lie against that or not, this is something which is extremely relevant, and that you must explain how it is amenable to the jurisdiction of the High Court under Article 226. As I said, writ petition cannot be maintainable against an entity or individual which is not state or which is not state authority. So the second aspect of drafting of the writ petition, which is extremely crucial, is you must explain how the respondents are amenable to the jurisdiction of the High Court under Article 226. Amenable means how they are state, how their functions, their discharge of power is subject to the scrutiny of the jurisdiction by the High Court. The scrutiny by the High Court in its jurisdiction under Article 226. So this is second aspect of the drafting. Third thing, just remember that since you come to the court because some right of yours is violated, you must spell out what kind of right you hold, what kind of right you possess, which is alleged to be violated. So you must spell out, you must explain what is your right, under what provision of a statute you are claiming to have such a right, and how that right is violated by a particular action of the government or the state. So you must spell out what way your right is violated. One thing. Sometimes you are not saying that my right is violated, but allegation may be or case may be that somebody is failing in his duty. If you say that so and so authority is duty bound to do so and so, and it is not discharging that duty, then you must explain what kind of duty is cast upon the respondent authority. Under what provision of law you say that that duty is cast upon it. With regard to allegation of right, just yesterday I read the news about the Supreme Court judges observing in one case, right to use WhatsApp is not a fundamental right. Now, just remember, you can't be very casual in saying that this is my right. On what basis do we say that particular thing, doing a particular thing is my right? Is there any statute? Is there any provision under which you claim? Similarly, is there any statute under which a duty is cast upon the authority? So you can come either for violation of duty, violation of rights, or failure to discharge a duty. This is something very important. And if there is some illegality committed, you must spell out what kind of illegality it is. For example, illegality may arise because no notice is given, without hearing the particular order is passed, or a statute requires so and so procedure to be followed before a particular action is taken. That prerequisite of procedure is not followed, etc., etc. You must explain what is the provision, what is the nature of illegality committed, why you say it is illegal, etc., etc. This is something extremely necessary in our pleadings. Now, there is one very technical nature, and I have seen a judge of the Bombay High Court dismissing the writ petition on the ground. Theoretically, the writ petitioner must, under Article 226, must specifically claim that after the impugned order, impugned action is taken by the government, or failure to do a particular discharge of a particular duty, you must make a representation that you have failed in duty, my right is violated. Please take the remedial measures. And you must say so in the writ petition. If you don't say so, your writ petition is not maintainable. That may be, therefore, if, for example, somebody comes to you for filing a writ petition, you must say, if he has not made such representation, you must advise him, first do one thing, make a representation to so and so authority. Let us give him a time for 7 days to take action, remedial action, and then we will file a writ petition. So technicality is not the reason for dismissal of our writ petition. So this is again to be borne in mind when somebody approaches us for filing a writ petition, for presenting a writ petition under Article 226. And then what are the grounds on which we are seeking the relief? Grounds are distinctly to be pleaded For example, non-compliance of a procedural requirement. For example, the no hearing given. For example, breach of a particular provision which results into illegality, etc., etc. Sometimes there may be a requirement of pre-publication of a particular decision that not complied with, that may result into illegality, and therefore the impugned decision may be illegal, etc., etc. All those grounds must be specifically raised in the writ petition. And then we come to the last aspect of the matter, and that is the prayers to be made in the writ petition. The prayers, just keep in mind 2-3 things. I have explained in my narration in the beginning that people confuse mandamus and certiorari. People confuse certiorari and prohibition, or mandamus and prohibition. So when you are making prayers, you must be very clear in what kind of writ you are requesting the court to issue, against what authority, what kind of function. If it is administrative function, mandamus. If it is judicial function, certiorari. There is a reason why I am insisting for this. Now those days have gone, but in England, the prerogative writs can be issued only if the prayer made in the writ petition is appropriately made. And those days, maybe about 100 years before, English courts used to decline to exercise the jurisdiction only on the ground that you are asking for writ of so and so, when in fact writ of some other nature was required to be asked for. Only on that ground the writ petitions used to be dismissed by the courts. So stricter were they with respect to kind of relief, kind of writ you are applying for. And therefore, you must be very clear against whom you are applying for writ, what kind of writ you need to apply for, and even while drafting that, just remember, I don't know whether Richa, you have that prayer with you?
Sir, which one?
The prayer which I took in the See, I have made a example of prayer, the writ of mandamus. As I said, technically a particular writ has to be applied for. And if you don't apply for that writ and apply for something else, then the courts used to dismiss them. Therefore, the drafting of the writ petition should be careful, and which will be covering all possible situations. Just read this, that this honorable court will please to issue a writ of mandamus, or a writ in the nature of mandamus, or any other appropriate writ, direction or order, directing this is imaginary, the further part of the relief, respond number 3 to forthwith release the amount of compensation already fixed pursuant to the acquisition of the land of the petitioners. So writ in the writ of mandamus, or a writ in the nature of mandamus, or any other appropriate writ, direction or order. Just remember that you are careful while making a prayer, what kind of writ you are applying for. Similar is the prayer with respect to writ of certiorari. That Richa may or may not show, but come back to the earlier slide. This is about certiorari. That this on the court will please to issue a writ of certiorari, or a writ in the nature of certiorari, or any other appropriate writ, direction or order. Now here, please remember, mandamus is do this. Certiorari is against a judicial forum, quasi-judicial forum, therefore calling for the record and proceedings in application. This is again imaginary. Application number so and so decided by the responsible for authority, and after examining the legality, validity, and propriety of the judgment and order dated so and so, the same be quashed and set. What is certiorari? Certiorari is court examines whether the particular quasi-judicial authority has discharged its function, judicial function, appropriately within the judicial limits by following the principles which are to be followed while discharging that quasi-judicial function, quasi-judicial power. And therefore call for the record, examine the particular order, its legality, etc. And if it is found to be illegal, quash and set aside. This is what the certiorari is. Now come back, Richard, come back to the earlier slide, not mandamus, before that. Yes. So I was talking about the writs you will be seeking. Second is prayers must be directed against the state or its authorities, not against individual. I will give you an example. Suppose, for example, there is somebody who has constructed unauthorized construction and you want it to be demolished. If the private owner of a land has constructed a building without the permission from the municipal corporation, you can't ask that private individual to demolish. You can't ask the High Court to issue a writ against that private owner of the land to demolish that unauthorized construction. And therefore, the next point that I have said is more the relief. In that case, what we do, this is a drafting skill. You want the building to be demolished, but you don't seek a writ against that private owner. You implead him as a party because he is going to be affected, but you implead municipal corporation, which is a state under Article 12, and seek a mandamus against the municipal corporation to demolish unauthorized construction. So, if you can't eat like this, eat like this. That's the way it is to be done. So, relief is to be molded so that 226 requirements are duly followed, duly complied with. Because you can file a writ only against the state or the authority of the state or the officer of the state and not against individual. So this is what the drafting of the writ petition is. Making prayers is extremely relevant from that point of view. One aspect of the matter, and then I will be done. Apart from the individual writ petitions or the petitions which are ordinarily filed, there is one more branch of law which has developed enormously, and that is PIL, public interest litigation. PIL also is followed under Article 226. I have just one thing to say about the PIL. All other things will equally apply. But if somebody is filing PIL, there are 2-3 things that to be borne in mind while drafting the PIL. One, who are you? For example, a teacher who is terminated, he has to say that I am working in school which is aided and my services are terminated. This is good enough. But PIL is not for your cause, for your grievance. PIL is for something which is happening wrong. So who are you? What is your occupation? What are you in life? You are not some busybody. You are not some publicity interest seeker. Everything has to be satisfactorily explained by your locus. Locus here is different. Who are you? That you are a citizen with genuine public interest in your heart. What your occupation is, what you have been doing for similar kinds of causes for all your life, or earlier some few years before the filing of the petition, that has to be sufficiently explained in the PIL, one thing. And secondly, you can't file a petition for protecting the rights of an individual who is well established, who is very well secure in life. You can file a, for example, environmental cause, you can highlight through public interest litigation. For example, some arbitrary exercise of power in allotment of government lands, you can file a public interest litigation, but you have to explain who are you, how you are public spirited, what your occupation is. But if you are filing a petition for somebody who is oppressed class, you must also explain why they are unable to go to the court, why somebody needs to represent them by way of PIL. This also becomes necessary in your averments, in your pleadings in the writ petition. When you file the PIL, just keep this also in mind. I think with this, I have explained whatever I could in for the house, I leave it for carrying on the further process.
Thank you so much, sir. So, students, till now you must have got a very good clarity, and sir has beautifully shown us how constitutional provisions translate into real advocacy. And I'm sure each one of you has gained a much clearer and much in-depth understanding of approaching the writ petition, the writ drafting with both confidence and precision. And now, before we move to the Q&A section, which we will be having, sir will be catching a break, and meanwhile, we will be discussing about something different, but it is very much related to the very theme of the session, the very webinar idea. So, see, here I am going to discuss about a very important point. Most of you are either law students, law graduates, lawyers, or advocates, and when we are talking about this particular thing, we consider one of the very important thing. We were talking just about how drafting is done, how repetition is to be done, what are the requirements, what are the things you must keep in mind when you are putting down the drafting thing. But this is something which we need to understand, that in law colleges you get the foundation of each and everything, like the sections, the provisions, you get to know the foundation in depth, like articles, judgment. But when we reach the courtroom, we actually face the reality. I have also been in that spot, and I believe most of you will connect with me, that foundation, the actual foundation which we get into the college and the real courtroom practice is actually different. When you get into the real courtroom, you get to see that there are different world. You are having drafting errors, procedural confusions, local practices are something which you are not aware of, and then there are the challenges of presenting the case before a judge. That is where the real learning begins, and that is exactly the gap which we aim to bridge with our course, which is provided by the law learning bench, and the name of the course is Courtroom Advocacy Skills Training Program. In short, I will discuss about this. So the course is of 12 weeks, having a duration of 12 weeks, and in these 12 weeks you get to have live interactive program conducted by senior advocates, former judges, and legal experts. Now, coming to the thing, that what you gain from this course, right? So, in these course, the live sessions provide you the very foundations. You get the courtroom simulation, the drafting exercises, oral advocacy training, as well as personalized feedback from mentors who have spent their years inside the real courtroom. So, the whole idea of this course is very simple, to help you move from the foundation which you have got in the law colleges to the practice and the power to grow in the real courtroom practice. And beyond this course, we are also going to provide you some of the additional things, like we are going to provide you an extended mentorship which will be provided for 1 year, in which you will get career guidance, you will get a very good clarity about whatever things you are working with, whether it is drafting or any other things. And apart from that, you also get free access to all the live webinars and resources. And with the completion of this course, when you enroll in this course, you get certificate, and the 5% of the top performers also get letter of recommendations written from the judges and seniors, which is definitely going to support your professional journey. So before we continue with the course, and we continue with the session, and we talk about the Q&A part, I would like you to please go through the contact details. If you want to discuss anything, if you want to connect with us regarding this course, if you have any query related to your career or any such things, you have the contact details on your screen. You can just scan this QR or note down the calling number, the WhatsApp number, and connect with us. So this was all about our course, and now we will be proceeding with the Q&A section. So I will be asking sir and all of you to please put down all the queries whichever is related to the session that you want to discuss with sir. You can just put down your queries in the Q&A section of the meeting, and we will put the questions before sir, and sir will try to answer as much as possible. Please take 1 to 2 minutes and write down the questions.
Yes, what is the question?
Let me look into this, sir. I'm just looking into the question part. Everyone, please post your question in the Q&A section. You might be not able to write it here. So, sir, I have just got one question, which is, while drafting a writ petition, what are the most common mistakes young advocates make and how can we avoid them?
I think there is an echo. You have to switch off that other. Yeah. Uh, some of the mistakes which normally are committed, which normally take place, I have already explained. You must be clear that this is not a petition under Article 227. This is not an appeal. So you are filing petition under Article 226 means these are original proceedings. All necessary facts, all relevant documents, all necessary pleadings have to be incorporated. First and foremost, locus, who are you? How are you aggrieved? That has to be explained. And third, who the respondents are, what is their statutory position in the context of the grievance that you are making, that has to be sufficiently explained. I think these are the elementary things that you must not miss sight of. And what happens many a times is that people in the High Court, I have seen that many a times they keep on filing appeals. In appeals, for example, in Bombay High Court, I have practiced for 11 years, I know. You just start with being aggrieved by the judgment and order dated so and so, or judgment and decree dated so and so on the following amongst other grounds, and you just raise the grounds. That's all. Not so in original proceedings under Article 226. One thing. Secondly, simple prayer that the judgment and order dated so and so be quashed and set aside. This is not a petition under Article 226. This may be 227, not 226. These are the common mistakes which I see taking place and about which I have wanted to caution since beginning, which I do again.
Yes, sir, we have another question which is from Sanjeev. He's asking for PIL drafting, the structure is like writ or altogether different?
No, there is no different structure. Structure is same. What kind of writs you want the court to issue? Same thing. Locus, same thing. But in locus, apart from what is normally applicable in case of ordinary individuals or individually private parties writ petition and PIL, is that what way you are concerned about the particular cause that you are ventilating. You are not busybody, you are not somebody who is craving for publicity, or you have some scores to settle against somebody and therefore you are filing petition. This is what the courts do not like. So about your credentials, about your, for example, just last week I was appearing before Bombay High Court in Goa bench, and it was a PIL. And the court asked me, who are you? And let me be frank, unfortunately in that writ petition, nothing was explained about him. That he is a public spirited citizen, that's all. So what do you do in life? What is your occupation? How you earn your livelihood? Nothing was explained. That court asked us, so social work is your source of income? I just smiled and I had no answer. So these are the questions that the court is bound to. One more important thing about PIL. Sometimes for example, environmental issues, some new project is undertaken by the government and you feel that this will be environmentally disastrous. Saying so is not sufficient. You must do a research. You must have some kind of compilation of necessary relevant information. You must have the opinion expressed by some experts in the field. you must have some kind of technical and scientific data available with you. So if that kind of issue is raised in the PIL, that academic preparation, that subject related preparation also is extremely important in PIL. Just keep that in mind. You can't just straight away say that this project is undertaken, this is environmentally disastrous, so direct them not to start that. It has
So
to.
then, yes, sir. Shall I put down another question?
Yeah.
So, sir, Naveen Kumar is asking, sir, are there instances when a private body is amenable to writ jurisdiction as they may be discharging public duty?
I gave an example of, for example, the private school, aided school, it receives for all its expenses the grant in aid from the government, and school is imparting education. So there are judgments of the High Court where they have taken a view that even a private aided school, which is discharging public function of imparting education, is amenable to the jurisdiction under Article 226. But I must also, it's a very funny thing, with respect to admission of the students, for example, government college, not private aided college. Suppose it is running medical college. You know what is the importance of admissions to the medical course. It is aided college, but it is not doing it in a transparent manner. You can always maintain a petition against that private aided government medical college, seeking a mandamus against it. Direct them to publish the list of merit within some time bound frame. Because discharge of public function, imparting medical education, is a very important public function. So you can, provided these conditions are satisfied.
Sir, someone has asked how to draft a writ petition challenging wires of amending provisions and how to seek prayer to read down the provision.
So you see, reading down is something different. We will first come to the challenge to the provision. When you say that particular provision of a statute or amending statute is illegal or unconstitutional, you must keep in mind that a provision of a law can be challenged only on limited grounds. One, that there is violation of a fundamental right. Two, there is violation of a constitutional provision. Three, the particular legislature, for example, state legislature, does not have jurisdiction, authority to make law on the subject. I will give an example. For example, the mines and minerals, heavy minerals, is a subject falling under the central list, list 1, schedule 7. Suppose a law is made by the state legislature with respect to the mines and minerals of heavy minerals or something like that. I don't know exact entry. Or banking, for example. Banking is a central subject. And state makes a law with respect to banking. Then the state legislature does not have authority to make law with respect to the subject of banking. So if it is violation of fundamental right, if it is violation of any other provision of the Constitution, or if it is not falling within the subject jurisdiction under the Schedule 7 lists, then it can be challenged. It can't be challenged about generally because you don't feel that the particular statute is not correct.
Sir, we have another question from Rajiv Kumar Yadav. He is asking, what is the basic difference in PIL and writ petition with practical implications? How locus is determined in both?
In ordinary writ petition, as I said, you must be directly aggrieved person. You can't say that so and so person has suffered some illegality and therefore direct the government to take remedial steps with respect to his violation of his rights. You can't do that. You can come to the court. Basic rule is that only a person who is aggrieved by some illegality or action or inaction can come to the court. So you must show how you are aggrieved by that whatever decision, action, illegality or inaction, etc. etc. PIL is exception to the rule of aggrieved person. Even a person, I will give very well-known example. Bandhuwa Mukti Morcha is the case when in some parts of Bihar, I think if I'm not wrong, some zamindars used to have a few workers and their families captive in their property for years, decades. They are not allowed to go out. They can't have their own volition. They can't do anything without their permission. So Bandhuwa Mukti, they bonded labor. They can't go to the court saying that our rights are violated. Somebody has to represent them by way of PIL. So if some persons of such category are actually suffering because of some illegality, then and who are incapable of going to the court of law, naturally some public spirited citizen has to take that cause to the court. Therefore, PIL. So PIL is exception, but provided the affected class is such that who does not have means, resources, the infrastructure to approach the court, or some causes are of environmental damage. For example, you know that that's the Captain Satish Sharma, minister, in his property had changed the course of the river for building a hotel. Environmental damage, environmental issues. I am not aggrieved. I am staying in, that was happening in Himachal. I am staying in some Uttar Pradesh. But changing the course of the river, you can imagine that too in Himalaya, what kind of implications it will have. So somebody has to take up that cause, PIL.
So, sir, we do have many more questions. I'll request you to take one more, which is from Ashish Kumar Dagar. He's
Yes.
saying, will the court dismiss the PIL if there is another legal remedy available, like filing in a lower court or using an administrative channel?
See that existence of alternative efficacious remedy is a rule which is a general rule. But I must also tell you, this is something I did not say in the beginning. Those initial rules of precaution I told you, when you draft the petition, inquire whether there is any alternate remedy or not. These are they are not creating a bar on the exercise of jurisdiction by the High Court. It's a self-restraint rule evolved by the High Courts. So in appropriate case, even if there is alternate remedy, High Court may entertain the request. It's all ultimately within the discretion of the High Court. But as a general rule, the High Court will not entertain a petition if there exists some alternate remedy.
Sir, I'll ask you to please take one more question. This is from Keshav Raj Deshpande. He's saying, can a public-private partnership between a government ministry and a private company, such as one involving the installation of AI cameras to prevent littering, be challenged through a writ petition on the ground that it violates the fundamental right to privacy?
It can be. It can be. For example, the cameras installed at a place where my privacy is going to be affected. The work may be given to private agency, but it is what is being done at the behest of the government. So certainly it can be subject matter of the petition under Article 226.
So, sir, we do have more questions, but I believe you must have, like, we are running out of time. So, that's okay, sir. We will provide them the answers through mail or something else. But I would like to extend my gratitude towards you, sir, for taking your time to share your deep knowledge and experience with us today. And I would also like to thank each one of the participants who have joined us and actively engaged in the session. We still have many questions left, but since sir has other commitments and sir has provided us for 1 hour, so we have to respect that as well. So this was all about today's session. Thank you so much, everyone. Thank you so much, sir. Thank you, Mitlesh sir, for providing us this platform. And if you want to know anything about the CASTP program, the course which I was discussing, or if you are interested in joining the course or our next batch, then you can reach us through the contact details which we have provided. So certainly reach out to us and stay connected with us for the more such webinar session. And sir, I would also like to point out that some of the participants has especially mentioned in the Q&A part that the session was very informative. They have actually asked me to convey you the same. Thank you so much, sir, for your time. Thank you, everyone.
Thank you, sir, for all your efforts for our legal fraternity, sir.
Thank
You did a
you.
great job. Thank you for considering my request. Thank you, sir.